12, and the meeting will come back in order. There's no actions out of executive session. Let's go on to the approval of the minutes. Commissioners, you've had the opportunity to be able to review the minutes. Motion be in order to accept.
So moved.
A motion and a second. Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Commissioners, if you don't mind, I would like to venture off into staff reports, primarily in HR, and recognize a few folks in the human resources that have retired. We do have our, I would say very own, but he's no longer with us, Michael Kelly. Michael, can you stand? As you know, and I think in our last meeting, we had, it's Colonel, but he's now, is he still Colonel?
He's a brigadier.
Brigadier General. That's right. Black that went to, I believe he's in Florida now, isn't he?
Sir.
Yeah. So he retired, and we found out that Michael is leaving also. Michael's last day will also be the end of this month, if I'm not mistaken. Michael has been an invaluable member to our government relations team. I hate to see him go. I know that he's going to go on to I wouldn't say better things, because I don't think he gets any better than TMR. But he's going to go on. He's going to be able to prove himself in another arena, I'm sure, of how competent he is and how great he was with this agency. So, Michael, if you don't mind, come up here right quick. I want to be able to congratulate you personally.
Mr. Chairman, this is a little awkward. Typically, Michael's the one taking the 1,000 pictures of everybody. So I don't know how this is going to go down. Okay, we got somebody back there. Yeah, thank you. Yeah, come on,
Gig'em.
Yes, please do. I can't believe he said gig 'em.
On the record.
For the record.
For the record. For the record.
My son and my money go to Texas Tech.
Mr. Chairman, we'll take care of that. He won't be here after this month.
Thank you.
Stuff like that.
Commissioners Mendez, Chairman Mendez, and the commission, I wanted to say a few words. First, want to thank you for your service here to Texas. You were appointed to lead the commission, to help lead the agency. You do it for no pay, and you volunteer, and there's no greater service than public service. I want to say personally, thank you, having seen the many hours you put in. I know you guys have your own businesses, your own families, and it's really important for us to have your leadership here. I want to say that I appreciate as well, Mike, the guidance that you give us from time to time and some of the stories you've shared with us. Your inspirational stories help us remember what's important about serving here at TDOR. I think the story that I'll most take with me is about Navy guys, and that's guys being generic and gender-free, Brian. So, how they pack these parachutes for these geese to use in case the geese get shot down flying in a V formation over a NASCAR track or something like that. So thank you for your advice and for the inspirational stories.
Well said, sir. Well said.
my
Well
God,
said.
that's hilarious.
I was asleep at that time, so I appreciate the review.
So that's what he was talking about.
I was asleep.
And there's a page 2. Okay, go ahead. There's more.
Under page two.
Oh my gosh, that's hilarious. That's a good one.
I want to say thanks to Brian. Brian, I've worked for 7 Army colonels, 3 state senators, and 6 different agency directors, and by far you've been the most competent, the most knowledgeable, the most dedicated I've ever worked under. And more importantly, you not only are a knowledgeable leader, you're a compassionate leader. And you are, to me, a friend. You're not just my boss, you're somebody who I'll always be friends with. And I thank you on behalf of all the agency, because I know we as employees appreciate your dedicated leadership and the time and energy you put in. Right back there I want to thank as well Kay for the work you've done, and Rhonda, I know you're listening. It's said behind every successful man is a woman rolling her eyes, and I see that all the time with Kay and Rhonda. But if it were not for the long hours Kay and Rhonda have put in, there's no way the executive would work. And I know Carla, you and Nick have seen that up front as well. I want to thank Carla and Nick. You guys came in right before the legislative session and just took off. You jumped right in. I appreciate that you guys took on this important role of leadership in our agency, and I wish you guys well as you continue. I know y'all have experience outside the agency that you brought to the agency, and it's certainly greatly appreciated that you wanted to come here to serve. So thank you guys for being here. I also want to thank my fellow employees. I consider you guys not just colleagues but friends, and I look forward to staying in touch. Some of you on Facebook, right, at least keep up. And I appreciate the fact that we can stay in touch. The last thing I want to mention, whenever I was first looking 5 years ago at coming to work at TDLR, I was most impressed with the strategic plan and the fact that the agency lived and followed by the core values. And I'll say the one big lesson that I've learned in the 5 years is using the 7 core values at TDLR. And one way that I learned them whenever I was getting ready to interview with Bill and Brian and Jeff Kopis, I came up with an acronym, TROICA, which is in the order teamwork, respect, open and free communication, integrity, innovation, customer service, and accountability. And that way I could remember what it was. But a TROICA, by the way, is a carriage pulled by 3 horses. And the key to success of a TROICA is you have to have a skilled leader in the carriage to guide the horses. And the horses are all 3 abreast, so they're equal. In order for that carriage to pull right, they all have to pull their equal weight and work together. And I would just encourage you, as commissioners, leaders, and employees, to continue to live the core values of TDLR, because that's a lesson that I'll take with me, because I think you can apply those core values that we have here anywhere else in your life, professionally and personally, and that's the lesson that I'll take with me along with the friendships that we have here. So I appreciate the opportunity to be able to come say goodbye. I appreciate, again, the service of our leaders, of our employees, and I look forward to staying in touch with you.
Excellent.
Thank you, Michael. For those that don't know, I think that you may not know it, but Michael's also an adjunct professor, so he teaches government. So not to mention his years of service as a military veteran, and so we are especially thankful for that. We also found out that yesterday that our own very own Robert Rennick is going to be retiring at the end of this month also. So Robert, we're going to miss you. We're going to miss your contained, descriptive, as you would describe in the cases, and we know that you had to contain yourselves a lot of time, but we appreciate your work and what you've done for the agency. He and I were talking earlier, and I asked him what he was going to do after he retired. He said nothing for a few weeks and a couple of months. Then he would decide what he's going to do. So he said that he left the door open, said that who knows, I may be back. So I hope that you're on this side of the table and not that side. So, but I appreciate your work. Thank you very much. Let's go on now to F in our contested cases. We have F1, which is Regal Nails. I don't have anybody at this point in time here to speak on contested cases, but if you are, we would tell you that you need to simply confine your comments to those that were at the ALJ hearing, if you went before a hearing. And if not, you have to basically contain yourself to what is currently in the record. So, which makes it kind of difficult sometimes. So, go ahead.
Thank you. Good morning, Commissioners. Chairman Arz Mendez, Commissioners. My name is Hasib Abdullah. I represented the Department at the SO hearing in this matter. The Administrative Law Judge found for the Department on all the violations that were alleged. The case stems from an inspection of a licensed cosmetology, esthetician, manicurist, specialty salon named Regal Nails in Laredo, Texas. The department inspector found many violations when he inspected the salon. However, the most serious of the violations were the 2 cases of unlicensed activity. The ALJ found that the respondent had allowed 2 individuals to conduct manicurist services when they were not licensed by the department. The department inspector testified that during a previous inspection at the salon, The respondent was also employing an unlicensed person, and as a result of that violation, the department issued a warning letter. The respondent claimed that in the earlier inspection, which resulted in the written warning, the unlicensed employee was just a potential purchaser of the business from California who was not working at the salon, but only there to observe how much business the salon generated. In the present case, the respondent again claimed that the two people observed by the inspector were simply interested purchasers from California. However, the evidence, including photographs taken by the inspector, again proved this to be false. The department requests the commission to adopt the PFD as written, and I'm happy to answer any questions that you may have.
Any questions for us, Steve? Is there anyone here representing Regal Nails? Commissioners, a motion be in order? Make a
Move
motion
to
approve.
accept 50.
We have a motion,
Second.
second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item 2, Willie Deason. Mr. Medlock.
Good morning, Commissioners. My name is John Medlock, and I was a prosecutor that represented the department at the SOA hearing on April 26th of 2017. Back in March 12th of 2014, Mr. Deason performed electrical work for a homeowner when he was hired in part to rewire the homeowner's garage. Mr. Deason, at the time of the work being performed, did not have a license issued by the department. The department charged the respondent with performing electrical work without having the required license. The department presented evidence at the hearing that included checks with the word electrical work on the memo line, an invoice and testimony of the homeowner where the work was performed. The ALJ concluded the evidence presented established that the respondent had performed the electrical work in violation of the statute. However, due to some mitigating factors, the ALJ reduced the penalty from the $4,000 the department had sought to $1,000, which is still at the low end of the range for this Class C violation. I recommend that you adopt the PFD, and I'm available to answer any questions you might have.
Any questions?
No questions.
No one's here representing Willie Deason. Commissioners, a motion be in order?
I move that.
Second.
We have a motion and a second. All in favor signify by saying aye. Aye. Those opposed, motion carries. Item number 3, Joshua Lira. Thanks, John.
Morning, Commissioners.
Morning.
We've got 4 cases here today, and
We can take them one at a time.
I suspect whenever I retire, there'll be a one-word speech instead of all that other stuff that you gave these others. And that one word will probably,
That can be arranged.
I expect it'll come easy. Well, the first case I have is Joshua Lita. My name is Ken Sharp. I'm an enforcement prosecutor with the department here. Mr. Lita applied for an apprentice electrician license. The administrative law judge recommends that you deny that application and actually he applied for a renewal of his electrician license. The recommendation is that you deny the renewal and revoke his underlying license. The department issued the license to Mr. Lita on August 25th of 2014. It expired on August 25th of 2015, and then he applied for a late renewal on July the 5th of 2016. In 2014, Mr. Lita was convicted of criminal trespass of a habitation and sentenced to 1 year in the Travis County Jail. The court suspended the sentence, however, and placed Mr. Lita on community supervision for 2 years. Now, he also pled guilty to resisting arrest and was placed on deferred adjudication community supervision for 12 months. These charges arose when Mr. Lita broke into an apartment belonging to a woman he claimed owed him some money. So he took a video game and a video console in order to satisfy that debt. During the course of his arrest, he refused to comply with the officer's requests and orders, and he also physically resisted them. He even kicked at them until they were finally able to restrain him. In September of 2015, the court revoked Mr. Lita's community supervision for the criminal trespass charge and sentenced him to 30 days in the county jail. The court also revoked his community supervision for the resisting arrest charge and found him guilty and sentenced him to 25 days in jail. Then in October of 2015, Mr. Lita was placed on deferred adjudication community supervision for 6 months after he pled guilty to unlawfully carrying a weapon on restricted premises. The police had charged him with that offense after he carried a gun into the Pluckers wing bar where he was employed at that time. The ALJ concluded the deferred adjudication should be treated as a conviction for purposes of consideration whether it should be licensed. Now, the Commission's criminal conviction guidelines include crimes against the property, such as breaking into someone's home to steal something, and crimes against the person, such as assault, which would include assaults against police officers. The guidelines do not specifically include the weapons violation, but that offense is nonetheless concerning to the department in light of the violent behavior Mr. Lita exhibited toward the police officers during his arrest in that earlier incident. And also, the weapons charge occurred within 5 years prior to his license application, so it would authorize the denial of that renewal application and revocation of license as well for that reason. The ALJ recommends that you deny Mr. Lita's application for renewal and you revoke his underlying license, and the department asks you to adopt that PFD. It's a corrected PFD, by the way.
Any questions for Ken?
None.
Anyone here representing Mr. Lita? Commissioners, a motion be in order.
I move that we accept the PFD as is.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 4, Raymond Lee Mabry. Anyone here for Mr. Mabry? Okay, go ahead, Ken.
All right, the next one is Mr. Raymond Lee Mabry. He currently holds a journeyman electrician license, which was issued to him in 2004. The license expired in January 2016, and he replied to renew it that following August. The administrative law judge recommends that you deny the renewal application and revoke Mr. Mabry's license. Now, his criminal history began in 1985 when he stole a truck and received a 5-year prison sentence. He was 18 years old at that time. Now, after that, between 1986 and 2005, he was convicted of burglary of a habitation, resisting arrest, engaged in organized crime, assault of a family member, and evading detention. And then in 2015, Mr. Mabry pled guilty to aggravated assault with a deadly weapon. The court placed him on community supervision for a period of 5 years for deferred adjudication. According to that indictment, Mr. Mabry pled guilty to, he cut the throat of a man with a knife. He was 47 years old when he committed that offense. The ALJ concluded that Mr. Mabry had not demonstrated that he has the requisite honesty, integrity, and trustworthiness to hold a license, and that he's not fit or eligible for a license at this time. The ALJ recommended that you deny Mr. Mabry's license renewal application and revoke his journeyman license.
Any questions for Ken? Motion be in order.
Move to accept.
Second.
A motion second, all in favor signify by saying aye.
Aye.
Those
Aye.
opposed, motion carries. Engel,
So I think he pronounced it, Angel Rudiaga is the way he,
Rudiaga?
that's the way he pronounced it. And so I'll go with that. On October the 8th of 2016, Mr. Angel Rudiaga applied for an apprentice electrician license, and the administrative law judge recommends that you deny that application. In 1991, he was convicted of evading arrest and sentenced to 10 days in the Harris County Jail. He was 17 years old when he committed that first offense. In 1996, he was convicted of felony theft and sentenced to 180 days in the Harris County Jail. In that case, he had stolen a motor vehicle. In 1996, he was also convicted of burglary of a habitation and sentenced to 4 years in the state prison. In 2002, he was convicted of aggravated assault using a knife and was sentenced to 10 years in prison. Also in 2002, he was convicted of sexual assault of a child and sentenced to 10 years in prison. He was 22 years old at that time when he forcibly raped a 14-year-old girl. The Texas Sex Offender Registry identifies this applicant as a high-risk sex offender. Now, he was released from prison on March the 9th of 2012. The ALJ considered all the evidence, which included a false statement on one of his license applications, and concluded that Mr. Rudiaga does not yet have the honesty, trustworthiness, and integrity to hold the license. The ALJ recommends that you deny the license. The department asks you to adopt the PFD.
Mr. Rudiaga here. Any questions for Ken? Motion to be in order.
Motion to adopt the PFD as presented.
We have a motion second, all in favor signify by saying aye. Aye. Those opposed, motion carried. Item number 6, Stephen Hutchinson.
Mr. Stephen W. Hutchison is the application in this case. In July 27th of 2016, he filed an application for an incident management tow operator license. The administrative law judge recommends that you deny the license at this time. Between 1985, when he was 17 years old, and 2010, the applicant was convicted of these following offenses in state court. There were 2 convictions for misdemeanor theft, 4 convictions for felony theft, 1 for attempted theft from the person, 1 for credit card abuse, 3 convictions for burglary of a building, 1 for burglary of a coin-operated machine, 1 conviction for misdemeanor evading arrest, 1 felony evading arrest or detention with a vehicle, 1 conviction for unlawfully carrying a weapon, 2 for unlawful possession of a firearm by a felon, and 1 for possession of a controlled substance, amphetamines, less than 28 grams. In the state, this applicant served 8 actual prison sentences, although 12 prison sentences had been imposed. The most recent 3 sentences were suspended, but that suspension was terminated when he was sentenced to federal prison, which I'll get to in just a minute. And then some of that other time ran concurrently. He also had 7 different county jail sentences for the misdemeanor convictions, although the first one was suspended. Mr. Hutchinson then had 2 convictions in federal court. In 2012, he was convicted of possession with intent to distribute a Schedule II controlled substance. For that, he was sentenced to 68 months in the federal prison. And he was also ordered to undergo 3 years of community supervision after his release. In 2013, he was convicted of felon in possession of firearm and sentenced to 12 months in federal prison with 3 years of community supervision after his release. He was 43 when he committed those most recent offenses. The most recent one was the possession with the intent to distribute a controlled substance. He was released from prison on June the 2nd of 2016, and then he applied for the license on July 27th of 2016, just a little under 2 months after his release. And he's scheduled to remain under community supervision until November of 2019. For tow operators, the guidelines include crimes against property such as theft and burglary, crimes involving the receipt, sale, or distribution of illegal substances such as drugs, and crimes involving fraud or deceptive business practices. Those are offenses that directly relate to the duties and responsibilities of tow truck operators, and he was convicted of offenses in each of those categories. The ALJ concluded the applicant at this time does not have the fitness, the honesty, trustworthiness, integrity to hold a license and recommends that you deny the application. The department asks you to adopt the PFD.
Any questions for Ken? No one here from Mr. Hutchinson? Commissioners, the motion be in order.
Move to adopt.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thanks, Ken. Thank you. And we will miss you, just so you know.
Well, thanks. And I thought, maybe as short as I was, maybe I'll get more than just one word.
Was that 2 words?
Mr. Chairman, I think we're adding a new core value of smart remarks. Staff is really living up to it.
I think just remarks.
Not so much smart.
Touche, touche, touche.
Mr. Rennick, we did say
Short
the
timer.
best for last.
Well,
We
I
know
can't follow
You will definitely showboat in your last time being here.
yeah, I wish I could showboat.
Item F7, Gilbert Sanchez.
All right, Robert Rennick from the Enforcement Division. This applicant seeks an apprentice electrician license. In 1994, he was convicted in a Southern California federal court of importation of marijuana, a felony. In 98, he was convicted of forcible sexual assault by a jury in Harris County. The judge sentenced him to, after the jury convicted him, the judge sentenced him to 45 years in prison. Crime was committed in 1997. The victim was a 22-year-old female. The applicant was approximately 49 years old. He was released from prison to parole in August of 2014. He's scheduled to be released from parole in August of 2042. On his license application, he said that he had never been convicted of a felony. When he requested his hearing, his explanation for the false answer on the application was that it was an oversight, and he thought the question concerned only the last 7 years. However, when he testified at the hearing, the applicant changed his explanation of the false answer on the application, and then he went on to testify that he wasn't even the person who filled out the application, and that the person who did fill it out simply made a mistake. The ALJ recommends that the commission deny the application because of the severity of the crime, because of the age of the applicant when the crime was committed, because of the short time that has passed since his release from prison, and because the applicant falsified his application.
Hey, Bob, will you pick that mic up?
The department recommends that the commission adopt the PFD.
Any questions for Bob? Mr. Sanchez, present? Anyone representing?
Yeah, let's
Motion
grab
is-
the other mic here.
Keeps falling.
Well, all right.
So moved to accept.
Second.
We have a motion and a second. All in favor, signify by saying aye. Those opposed, motion carries. Item F8, Benjamin Henderson.
The department seeks to deny the renewal of the respondent's incident management tow truck operator license and revoke it. This license was issued in 2008. In 2002, he was placed on deferred adjudication for 10 years for burglary of a habitation. The respondent violated his probation. It was revoked in 2005, and he was sentenced to 3 years in prison. In 2004, probably the basis of the revocation of that probation I just referred to, he was convicted of possession of marijuana and failure to identify, 2 misdemeanors, and sentenced to 60 days in jail. Then in November of 2009, the respondent was placed on deferred adjudication for 12 months for possession of marijuana, a misdemeanor. However, he committed this crime less than a year after receiving his tow operator license. The marijuana was on the respondent's person while the respondent was operating a tow truck. In 2015, he was convicted of indecent exposure and sentenced to 180 days confinement in the Dallas County Jail. The sentence was suspended and the respondent was placed on community supervision for a year. The crime was committed in November of 2014. The victim was a 16-year-old girl who was standing on the side of a street waiting for a school bus. The respondent drove up in a car and exposed himself to the girl. At the same time, he asked her if she wanted it, at which point she said no and walked away. The respondent was born in 1981 and was approximately 33 when he exposed himself to this child. Additionally, when he filed his renewal application, he said that he had not been convicted of any crimes since his last since his last license was issued, even though he had been convicted of indecent exposure. The ALJ recommends that the commission deny the renewal application and revoke the license because of the nature of the indecent exposure offense, because of how recently it was committed, and because of the lack of rehabilitation evidence. The department recommends that the commission adopt the PFD.
Any questions for Mr. Rennick?
No question.
No one here for Mr. Henderson? Commissioners, a motion to be in order?
Motion to adopt the PFD as presented.
Second.
We have a motion and a second. All in favor signify by saying aye. Aye. Those opposed, motion carries. I think that concludes our contested cases.
May I make one brief statement, and I will keep it brief. I'm not as eloquent as...
As Tom?
Well, certainly not as Tom, or as Michael, or as Ken. But I would like to say that I've represented the department in front of the commission for 10 years, and none of you were on the original commission, except for you, Chairman, that when I began at the department. But I've enjoyed every minute in representing the department before y'all, and this particular group has been a good one, I think. We've had some interchangeable parts over the years, but I've enjoyed this group a lot. And I think you've treated me with respect, and you've always carefully considered my cases, even when you've ruled against me or maybe altered a disposition. But I always believe you did it fairly and for what you thought were good reasons, and that's fair enough in this world. And I also want to thank Mr. Bryan over there for his service as executive director, and for most of the time I was here, assistant executive director. I think you've been a great boss to me. I think TDLR has been a great place to work. And everyone who I know here, and I'm not going to name everyone's name, Brad, Bella. Stop there. all of y'all. If I don't mention your name, I've enjoyed working with all of you, and it's been a great time. Nick and Carla, I don't know y'all well enough to have formed a relationship with you, but I've had a very good impression of you since I've met you, and I'm glad you're here, and I think you'll be great assets to TDLR. Thank you very
I want
much.
you to know that from the commissioner's standpoint, we appreciate what you've done, and you're right. I think even I was here before you got here, which tells me I've got to be one of the oldest people here in TDLR. And I'm strictly volunteer. But we appreciate your work. I know that you dealt with each one of the cases, and you gave it your all, and you fought for every single case that you had in representing and protecting the citizens of Texas. And so we know that there's a lot of people that don't have their license because of the fact that you fought so hard for protecting the citizens. So I want to thank you on my part. I appreciate your work. Commissioners, I don't know if you've got anything else to say.
Yeah, I think it's been a good experience within a short time, so I'm gonna shake your hand. So come on forward here and thanks for your efforts.
Brian, you're running the best people off. What's going on?
We've got 2 new commissioners, and it just seemed right after that point.
So they're running him off, is what you're saying?
Let's move on to the motions for rehearing. I don't know who's starting. Oh, Doug, you starting? Elena's Beauty Salon. Anyone here representing Elena's Beauty Salon? I would tell you the motion for rehearing is not the opportunity to retry the case. The motion for hearing is the opportunity for you to tell us where the commissioners erred in coming to their decision. So if there is a problem in the way that we came to our decision or something that wasn't considered that was actually in the information that we had prior to, then you can bring it up then, but we're not here to retry the case. So I would ask you to confine your comments simply to what was at the SOA hearing or what are the facts in the case. So,
Somebody here.
go ahead. We will. Go ahead, Doug.
Thank you, Commissioner. Thank you, Chairman and Commissioners. My name is Doug Jennings, Assistant General Counsel for the Department. This first matter before us resulted from a default order in which the Department assessed administrative penalties totaling $1,500 based on the respondent's alleged failure to perform cleaning and disinfection of its Whirlpool foot spas, either at the end of the day or after use by each client. In her motion for rehearing, the respondent implied that TDLR's inspector merely gave her a warning to remedy the violations in question. She also states that the foot spa in question is no longer in use, and she requests a reduction of the penalty. But of course, the respondent here did not allege any errors of law, didn't contest our allegations in any way, and did not allege that she did not receive notice. So the division would recommend denying this motion for rehearing.
Any questions for Doug? A motion would be in order.
Move to deny.
We have a motion.
I do want to, I'll second
Okay,
that.
Go ahead, Commissioner Collier.
But there's, appears to be a typo, in some of one of the ones that I noticed. I can show you that later.
Is it,
It's in the factual allegations, unless I'm reading it wrong. Factual allegations, number 4. I think I barely did my signature here. Does that read properly there? I don't think it did.
is that where it begins on or about April 12, 2016?
Yeah, failed to perform the proper after each client foot spa cleanings. Something's missing to me.
I would believe the syntax is incorrect, Commissioner. I do agree with you. I do not believe that affects the substance of the
It does not,
NOAB.
but I would agree
Duly
there.
noted.
I'm just
Thank you.
particular with that. Thanks.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number G2, M Spa.
Another cosmetology case, Commissioners. And this matter resulted from a default order in which the Commission assessed administrative penalties totaling $1,000 against the respondent based on alleged failure to follow the procedures outlined in Title 16 of the Texas Administrative Code, Rule 83-108D, in cleaning and disinfecting whirlpool foot spas. Just a summary, that rule provides a very specific process to be followed when cleaning whirlpool foot spas. And in his motion for rehearing, the respondent alleged that scientific literature establishes that a different sort of disinfecting process is actually more effective than those outlined in the rules. Of course, none of us today are in the position to evaluate that claim. It would be helpful to have requested a hearing to discuss that, or to request a rulemaking. So nonetheless, we would recommend denying this motion for rehearing, as it has not alleged any error that the department made or alleged any error of notice.
Any questions for Doug? Motion be in order.
Motion to deny.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item G3, Easy Nails. I believe we do have Tao Nguyen. Is that correct? Come on up here and have a seat. Go ahead, Doug.
Thank you, Commissioners. In this case, this matter resulted from a default order in which the Commission assessed administrative penalties against the respondent totaling $2,000 based on a number of alleged violations, including failure to perform daily cleaning and disinfecting of 9 whirlpool foot spas, failure to maintain records regarding the cleaning and disinfection, failure to perform required biweekly cleaning and disinfection, and failure to clean and disinfect all 9 spas after use by clients in the manner required by law. In an email sent to the Division of General Counsel on July 10th, the respondent claimed that the case against her was a mistake and offered to provide proof that the salon complied with the law. But this email did not meet the legal requirements for a motion for rehearing, as it didn't allege any particular errors of fact or law, and there was no allegation that the respondent did not receive notice of the violations in question. And so our division would recommend denial of this motion.
This was a contested case, you said?
It was a default order.
That's a default?
Yes.
Okay, so it's a default, okay. Any questions for Doug?
None.
If you don't mind, are you here interpreting? State your name
Yes.
for the record, please.
My name is Tuvan. I'm with customer service.
Okay. State your name.
Good evening, good morning. My name is Thao Nguyen. I'm a responder and DBA for Easy Nail Salon.
Okay. Before you begin, I just want you to know, if you don't mind, and if you have to interpret or not, but we can only take into consideration what was basically in the facts in this particular case.
Hey, Carla, excuse me, Commissioner, do we have another microphone here? Or, okay, forgive me. Thanks.
I'd be glad to lend them mine.
Yeah, why don't you
Okay, that's
pass it
fine.
over right now?
Okay,
We can-
I didn't know if
we
you
can
needed
pass
to
it back
comment.
and forth. Thank you.
Yeah, it's Texas.
Just to make sure that she understands that she could only present what was in the case, and where the department erred in coming to the decision, so just let her know that. We can't retry the case.
I think I'm here for wrong because I have no idea that's what I'm here. I don't know who commissioning us. The case is what happened that we have to inspect on the end of November, and I have not know anything about the day that they inspect and the report. I have never seen that until the March 31st. I have the first letter from TDLR.
Have you
Then
given this information to the department prior to?
I called them back. I talked to them several times that I would like to explain that nothing, the
The problem
information.
is that you can't explain at this point in time why you didn't,
That's why
why
I
you had
know
these
that
things.
I'm in the wrong place now, but I will talk to them many times too. I would like to talk and explain, but they tell me to wait for the next letter, and then the next letter they say, if you not approve this bill and this file, that you can set the hearing motion. And for me, firstly, I understand the hearing and motion is mean that I can explain to the judge or whoever take the case or review my case or something like that. And I will question that until I have the letter to set appointment for today. I asked Mr. Brew that who is commission is, what that their function, and what should I do, what do I do to respond to the case. And so
Did we
I
show,
think I don't understand
NOVs being sent out?
And I asked about the process, that what the processes go, because.
Okay, who'd you talk to?
I'm-
Do we show any record of communication or any NOAV being sent out?
Yes, sir. Oh, it seems to work now. The NOAV was sent to the respondent on March 31st to the respondent's mailing address on record with the department. And as you know from the government code, mailing notice to the address on record is legally sufficient for this purpose.
Do we have a signature accepting, do we know?
We do have a record that the certified mail was delivered and left with an individual on April 5th, 2017, at that address of record.
So somebody got a letter from us. Was it you, April 5th?
April 5th, I have on April, no, I don't have April 5th, I have the
Do
May
you know the
2nd.
signature, is there a name?
I don't have that in my file before me.
Somebody received a letter from us and signed for it.
I have March 21st, May 2, May 3, June 16.
Well, and it could have been the March 21st letter. If it was April 5th, they accepted it.
Yes, it was dated March 31st, I believe. Well, that was the day it was mailed, so it may have been.
Oh, yeah, the March letter. So you
Yeah,
didn't
I
receive
called
that
Miss
letter.
Carol, legal assistant, the first moment I opened the letter.
March
like,
31st.
I never know this happened, so I would like to understand what will happen and why does somebody say that in this say the allegation 4 and 5, 6, and 7, they say the Mr. Tweefan said like we did clean the top of the, it nothing right.
Okay.
So I just
And
would
so
like
you
to
did
explain
receive-
to them.
Okay, so you did receive the letter,
Yes, I do.
but you did respond to someone?
I called
Did you
Miss
talk to
Carol.
somebody?
Yes.
Okay, and
And she told me to call back. I called back, and I think I talked to her totally 3 times, and they said the case will happen. They sent to, I wait to talk to the jail counselor, and then I have the next letter, and I call back, and.
do we show,
We have
I
some further
just missed in
information
the
that I think could
process.
clarify
Go ahead.
this, if you don't
Go
mind.
ahead,
Lindsay Powers from the Division of General Counsel has just a few details she'd like to share.
state your name for the record, please?
Lindsay Powers, Legal Assistant General Counsel. We do show that she contacted our Enforcement Division and spoke with Carol Taylor. I believe it was April 5th, so after the NOAV was sent. There was a lengthy discussion. She said she was going to review the document and contact us back. Next correspondence we show, she contacted us in June after the order had been signed and was referred to the General Counsel.
There was a communication between April and June that we showed.
Not that I show. I also show in the notes that she said her partner, I believe Mr. Pham, was the one who signed for the documentation, and so she was aware of it.
Okay. Any questions, Commissioners? Thank you, ma'am.
Thank you.
So you did receive it and you made a phone call, and then we're showing that you didn't call back until June.
I called Miss Carol back in the 3rd time. Yeah, because she told me to call back. The first time I talked to her all about the case, and she told me to talk to Tweefan and call back. I couldn't find him. I couldn't contact him. He moved to Houston since October last year, and the day of inspect is the 29th November. It's somehow that happened that he in the shop, but he not the one that respond everything in my shop, and for what he say, it's not it. But I'm not sure is who the inspector talked to exactly.
Okay.
Because I talked to him, he not respond to me clearly that he do anything to inspector, and someone in my shop say that there's another guy that his brother-in-law and talk to him, and I need to know, firstly I need to know what will happen, and I would like to I respond and I would like to explain, but whatever has happened in the report is wrong. Except we missed
Okay,
missed the record.
Okay, and again, we can't get into the details of the case.
I'm sorry, yeah, I know.
So what you're saying, but you received another letter in May, which was a default order, and you didn't respond till June. So something happened, because you said you talked to him in April, and we show that we don't have another record of you calling us or communicating with us until June, after the default order was issued. So did you talk to somebody after April 5th? Or
Right,
did you
the
talk
day-
to somebody again
Oh,
in
maybe
June?
the April 5th is the day that I received a letter.
Right,
I
and you
keep
talked
saying
to
the
somebody
121st,
then?
yeah. I called right to Mr. Carroll. I talked to Mr. Carroll, I think 3 times.
You talked to her 3 times?
I'm sorry, I don't remember the time.
That day or through the course of
No,
the
that day,
month?
and then I call back, yes.
Okay.
There's the time she said it's too late, she can do anything, but I don't,
Was that in
I
June?
ask people to, whoever respond or review the case or take the case, listen to me to explain.
Okay.
That it-
Did you talk to her the second time in June, when she said it was too late? Because by that time, if she said it was too late, was a default order already issued?
I don't remember the time. I remember I talked to Miss Carroll about 3 times. That's
Okay.
who I know for the first
Did you talk to her
letter.
after you got a second letter?
Second letter, mean the May.
Which would have been the default
2nd.
order,
Yeah,
notification?
After this letter, yeah, I call back.
Okay, is that the next time you
Be-
called her back?
After the early April, yeah, it take me a while to call back. I don't remember exactly the day, but I was looking for I tried to know what will happen. So I looking for them, I talked to them, but nobody respond the right information to me.
Okay, so my question is this, you talked to them in April.
Yes.
Did you talk to the department again when you got the second letter? Is that the second time you talked to Carol?
The second letter is the May 2nd in here.
Right. Is that the second time you talked to
After
him?
this letter, yes.
Okay. You didn't talk to him between there?
No.
Okay.
Chairman, may I interject?
Sure.
I believe what we have here is a very clear-cut case, in my opinion anyway. It's obvious that the notice of the alleged violation was sent, that it was received by the owner or the agent of the owner. There was an opportunity for the respondent to request a hearing. There are multiple contacts between the respondent and not only my division, but also in the enforcement division. So the respondent had ample opportunity to request a hearing to contest these violations that she says were a mistake. No hearing was ever requested, and that's why we're here today. And as you said, not to retry the case. So we would strongly recommend denying this motion.
Any questions for Ms. Nguyen? Anything else you'd like to tell us? Again, we can't go into the case.
Okay, I understand that. I don't know exactly the process for this case by the law. I'm the business owner. I hold 2 bachelor degree. I just know that I don't do the non-clean business. I do it right. I follow the law. I protect my client and my employee. I just want that things go right. So that is so wrong. I don't do that bad. So I just want to say it. It's not right for what we did. So I don't know by the law how that you can do it. I respond for my business. I respond for my job. I follow the rule. And I think I respect to get help and get lead or guide to do things right. And if it's wrong, I pay fine.
Thank you. Is there any questions or motion be in order?
I have a question for the counselor. So let me understand, on November 29th, an inspection was performed, and then I'm a little confused. Was the allegations or the inspections that were made, the results of the inspections that were made, were they sent in March the following year? Or am I understanding that incorrectly? Could you clarify?
Yes, it does look like the inspection was performed in November, late November of 2016, and the NOAV was sent in March, at the end of March of 2017.
Okay. So I'm leading the question, and this is for maybe the executive director. Is it our customary process and policy that after we've performed an inspection, we leave a client hanging until, what, almost 5 months later to tell them what we inspected and what the defaults were on that inspection?
Commissioner Shaw, after the inspection's completed, that individual is provided a copy of the inspection report there.
Immediately?
So they receive a copy of the inspection report. So the first time they heard from him was in March. The first time they heard from it in terms of a NOAV was March, but when the inspection's completed, they're provided with information about what to correct and those sort of things. So
Okay,
there's
so-
no gap between that notice.
So let me clarify. So what I'm hearing you saying is that after an inspection is done, the business owner is given the inspection results immediately,
They are provided a copy of the findings by that inspector.
whether they're written or typed or whatever.
Absolutely.
Okay, all right. I appreciate that. Thank you.
Yes, sir.
Thank you.
Any further questions?
Okay, I want to say one more thing. Actually, firstly, I don't want to be here because I'm nothing to do with TDR or something. I just want to do with my case, and then some things happen, follow step by step, and then I realize that it's good for me to be here to understand the process of the case or the law if we happen that to involve it. Because when the case is happened, it's the first time I've been run and managed the nail salon for more than 10 years. I take my license with English language. I know the law, I learn the law, and I do everything. And it's still the first case happened to me, and I get stuck. I don't know what to do. First time I talk to them, I say, I want to know the case. Because I don't know nothing about I have never seen the report, or I have know nothing that happened on that day. So it should be the law consider that I know that the inspector have the right to enter the business in any time that the business open to inspect. I know it's how the industry is grow big and grow fast that you have to manage this good. But so it's my business. I don't know what happened, and then like anybody can talk and tell the messed up in my business, or if the case happened, that I would like to take care of in the right way, but I don't know where to start and what to do. So actually it's a mess because it's my fault also because I don't respond anything in the mail or letter. I just call them and talk, and then I don't know that what department that I should to talk for this step. How do I do? Because first I just see in the letter that if you have any question, you call Ms. Carroll, legal assistant. Then I just pick up the phone and call her and say, Ms. Carroll, I have the case. And I'm shocked and surprised that I don't know it's happened like this, but it's not wrong. So
Ms. Lynn,
how
did you own
it's
the-
not right?
Did you own this business in November of 2016?
Honestly, I'm the partnership, but I take all the
So
manners
you're responsible
for the law because I do know,
I
and I
understand,
do.
but you're responsible for the business.
Yes.
And Mr. Pham was a,
Mr. Fan was my
manager?
silent partner. He not a manager.
Okay, he was a silent
He don't
partner.
know things, so I don't let he do things.
okay,
Yes,
but it's still your business.
yes.
Okay.
But he moved and he moved out since the end of last year, and then he sold the business to me since the beginning of this year.
Okay. I think Commissioner Shaw's got a couple of questions.
I do have a couple of questions, and I'm going to first ask the questions of the council, and then I'll come back to you. What is the total penalty that we're suggesting?
$2,000 in total.
Okay. But the original starting point was $7,000, am I correct?
I'll have to confirm that
Yes,
just a
sir.
moment. Thank you.
While you're looking that up, I have a couple of questions for you, ma'am, Ms. Nguyen.
Yes.
You stated, number one, you are the business owner, so you are responsible for whatever happens in your business.
Yes, I do respond.
Second, you agree the fact that the inspection was made and a copy of the inspection results were given to you, correct?
The copy of the report,
The inspection report.
I never have seen the report.
On November 29, did the inspector give you a report of all his findings or her findings?
I have an audit of
He left a copy.
alert violation. I don't have a report. That's why I don't know.
Did he leave a copy at your business when
Do I
he
need that?
performed the inspection? When
Do I
he
need
came to
that?
your business on the 29th of November?
I don't know if Tui-Fan have it, but I
Okay.
asked, and I have never seen it for real, for true.
Okay, so you only found out in March.
Yes, that's why I,
Okay. Let me stop there for a second. So you found out in March that there were some
yes,
issues with
that's why
your-
I'm so shocked. At the right
Okay.
moment I opened the letter, I called Ms. Carroll.
Okay. But from March till now, you have been in contact with the agency, correct?
Who's the agency?
TDLR,
Again? You say?
Texas
TDLR, us.
us, the
Okay,
department.
And what the question is?
You've been in contact with us, correct? With somebody,
You
Yeah.
be,
Yeah,
yes?
I mean, in the March, the letter of March 31st, the first time I received it, I called and maybe you say April someday, for the day that I received the mail, right? I received the mail, I called Ms. Carroll. I say, oh, I received
So
the
you
letter.
have been in contact with Carol or somebody with the agency?
Yeah, I did.
Okay. Back to you, sir. Did you find out what the original penalty was?
Yes, Commissioner Shaw, the original total was 7,000. Settlement offer for 5,250 was made, and it looks like it's been reduced to 2,000.
Yeah. So we've kind of settled on what, $2,000? Is that what you were saying?
Yes, sir.
So, Ms. Nguyen, here's where I stand at with this, and I'll let the commission kind of deliberate a little bit more, but I feel like we've been more than generous with you, and I know your reason for being here could be because of the high penalty that we're assessing.
Yes.
I feel like that the agency has done what it needs to do. It had left you, with enough time to respond back to us. You have been in connection with us, and I think that staff has been more than generous with reducing the penalty from 7,000 to 2,000. So, at this point, I'll leave
Any
it to
other
the
questions?
commission, I'll make a motion.
Make the motion.
Thank you, we appreciate it, we've heard you, okay? We appreciate it. Thanks, Doug. Commission? A motion be in order?
I move to deny rehearing.
We have a motion to deny.
I'll second that,
and
Chair.
a second, all in favor signify by saying aye.
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 Those opposed, motion carries. Ms. Nguyen, just so you know, staff will be in contact with you. You do have further remedies past the commission, and they can kind of explain that to you.
Okay, so whatever I need to talk or explain, I'm gonna talk later with TDR.
TDLR will contact you. Will somebody contact her?
Absolutely,
Yes.
Mr. Chairman. In fact,
Someone will
they'll meet
contact you and
outside.
tell you what your further remedies are.
Right.
You can take this into district court if you'd like. Okay?
Are there any, anybody here who could review process with her while she's here?
Yeah.
Cleaning and
yes.
stuff, I mean, should we take
Yeah.
advantage of that?
Yeah, well, I'm sure
Mr.
somebody
Kelly,
will
we'll
contact
have our
you.
enforcement
Got it.
division as well as Tuvon and
Someone
customer
will call
service
you.
to just sit with her outside as long as they need to.
All right, thank you.
Thank you.
Thanks.
Let's move on to item G4, Hawkins Coal Partners LLC. I believe Beth Austin, go on and have a seat. Go ahead, Doug.
Good morning. Thank you again, Doug Jennings, Assistant General Counsel for the Department. This matter resulted from a default order in which the Department assessed administrative penalties against the respondent totaling $2,000 based on the respondent's alleged failure to have its building inspected for accessibility compliance within 1 year of the completion of construction of the building. Completion of the building in question was completed in November of 2013, and there's no evidence that the required accessibility inspection was ever completed. In its motion for rehearing, the respondent alleged that it believed its general contractor was responsible for handling all the inspections required for the building. However, according to the Texas Government Code, the owner holds the responsibility of securing the required inspection, and that is Government Code 469.105A. In its motion for rehearing, the respondent did not allege any other errors of law, did not contest our allegations in any other way, and did not allege that it did not receive notice. Therefore, we would recommend denial of this motion.
Any questions for Doug? Ms. Austin, I'm sure you probably heard the conversation we had earlier. You can only confine your comments to the facts that we have before us. This was not a contested case, so it's just whatever we have before us, and you can only discuss how you believe that the department erred in coming to their decision. So, if you don't mind, state your name for the record.
Beth Austin.
Go ahead, Ms. Austin.
I actually am here on behalf of Departure Lounge. I don't work for Hawkins Co. They are the owners of the space that we leased from them.
Okay,
We
hang on
received a
just-
copy of the certified letter saying that
Okay, hang on
we
just a
owed
second
money.
then. You're with Departure Lounge, who leases space in the building?
The space that they're saying is in violation, we're leasing it from Hawkins Co.
Okay,
All right,
so, okay, we got a problem here then,
Mhm.
because
Yeah.
we should have representatives from Hawkins Co. here and not Departure Lounge.
Right, and
So, that being the case, I don't know if you, I don't even know if we can have you come forward and speak on their behalf, because as far as we know, you're not authorized to speak on behalf of Hawkins Co.
okay.
This is, yeah, Brad Bowman, General Counsel. I would think that the case is against the owner of the property, and I don't know that they're standing for the tenant to represent.
And I don't believe we have received any letter of representation that would really authorize,
Anyone to speak on?
yeah, anyone to speak on their behalf.
Ms. Austin,
So I
I'm
can-
sorry, but we have to cut
I was
off your
like, sorry.
communication with us. I'm just gonna go ahead and
No
mark
problem.
through this and act like you weren't here. All right?
She has received. We didn't mistake it.
Yeah, I don't know how she got that information.
Do you mind if I ask you what brought you here today? What, was there a piece of paper that? From the TDLR?
Was this addressed to your business?
This was addressed, well, each of them.
Does Keith Walden,
He is out of town right now, and he told me to come here and represent him on behalf of Departure Lounge. And we got this letter saying that there was this violation in 2000.
hey Brad, do you see that Keith Walden,
We've,
are you a owner with Keith Walden, or you only
No.
work for
we
him?
brought the
I'm
tenant
just
in.
part of this.
And do you have anything showing that he asked you to come before?
We requested the tenant to show up.
Keith is owner of Departure Lounge,
Yes.
and you represent him. And then the leasee of the Hawkins building.
So what they ended up getting, we got this letter here, where they had requested an inspection and asked for money,
This
which
is
we
genius.
sent,
Oh,
which
my
we sent.
goodness.
Okay, hang on
We
just a
should
second.
probably
Let
have-
us,
Whatever discussion we're having, we should probably have it on.
That's what
I'm
the
saying, Mr.
microphone
Chairman.
and-
well, even at that,
Just have a seat
why
for
don't
one
we,
second.
let's have a,
Let's
here you go.
unpack this a little bit.
Here you go. Can you mind taking this?
And I'm trying to look
Letter.
through the notices to see
No.
why we
Yeah.
We sit with,
included.
Go ahead. Let's do this. Why don't we go past this one right now, and let's go on to G6. If you don't mind, Ms. Austin, can somebody get with her and find out what we have? Because
Little guy.
there's obviously some other additional information here that we're not aware of, because Keith Walden is also included in the letter, which we don't know why he's in the letter. So,
Plus he owns the building.
yeah, so anyway, just get with them. Let's go on to G6, and then we'll take a break, and we'll come back. After the break, we'll come back and take up your case.
Okay.
Okay? Let's go to G6, William Abraham. Doug, go ahead.
How about GP Hotel?
Oh, I'm sorry.
GP Hotel.
I'm glad you mentioned that. G5, we did receive a email from the Chief Financial Officer from Pandy Hotel, and they have requested to withdraw their motion for rehearing, which we have that information. So
Okay.
they have, motion for hearing for Pandy, which is actually GP Hotel Dallas, has been withdrawn. So let's move on to G6, William Abraham.
Thank you, Chairman. Again, Doug Jennings, Assistant General Counsel for the Department. This matter resulted from a default order in which the Commission assessed administrative penalties against the respondent totaling $10,000 based on the respondent's alleged failure to secure 5 required annual inspections for an elevator located on a property situated at 717 East San Antonio Avenue in El Paso, Texas, between the years 2009 and 2014. In his motion for rehearing, the respondent alleged that he is not the owner of the property in question. However, a quick review of the records, a quick but thorough review of the records held by the El Paso Central Appraisal District showed that the respondent held 100% ownership on a personal basis in the property from April 10th, 2009 until July 7th, 2014. And so it does appear that the respondent was in fact the owner of the property during the time of at least 4 of the 5 allegations outlined in the NOAV. It does get a bit more tricky here. The 5th inspection was performed, I believe, in August of 2014. The records show that the respondent executed a warranty deed to Franklin Acquisitions LLC effective July 7th, 2014. So taking that at face value, that means that Franklin Acquisitions would have been the proper respondent in regard to the last violation. So that would be the factual allegations outlined in paragraph number 5 of the NOAV. And therefore, what we are recommending in this case is to deny rehearing on the first 4 of the allegations that the respondent did not perform the required inspections for the first 4 years. But the last one, we would like to grant the motion just regarding factual allegation number 5 in the NOAV. And we would recommend that the administrative penalty be reduced from $10,000 to $8,000. So what we're doing, what I'm recommending is that we deny rehearing on 4 of the 5 allegations, grant with respect to the most recent, so that we can re-NOAV Franklin Acquisitions LLC as the proper respondent and reduce the administrative penalty accordingly.
Any questions for Doug?
I just want to catch up a little bit here. A couple of things. I show the physical property located in Dallas, not El Paso.
With the next session.
I'm sorry. I thought we were still with G. I'm catching up. I withdraw my question.
Any other questions for Doug? Anyone here representing Mr. Abraham? So, Commissioner Shaw, were you about to say something?
No, I was
Oh,
about to
okay.
make a motion. sir.
Now, this does have a response from Mr. Thielen, but I'm just assuming you're okay with what we're about to do, because that's the recommendation of GC. So, Commissioners, a motion be in order?
Move to deny the first four, allow for the fifth, and then reduce the penalties 10 to 8.
So moved.
A second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. It is about 10:15. Let's take about a 10-minute break. I would ask that someone get with Ms. Austin. Let's try to figure out what we got here so we can take this case back up after we finish. All right, so let's go ahead and take a break.
Pigley's comment. H, Mr. Mike?
But then we'll come back to it, but then we'll go to H. Okay. He'll come back in order. I do think that we need to check with our media people to make sure that this purple is not flashing or distorting the view of where.
Mr. Chairman, we'll look into it.
Thank you.
And also, we'll implement that dress code coming in September.
Okay, let's go back to item G4, Doug. I believe we've figured out this issue.
Yes, again, Doug.
I would make note that Ms. Austin has left, so I guess we have satisfactorily talked with her, so she's okay.
Yes, Mr. Chairman. Again, Doug Jennings, Assistant General Counsel. We spoke with Ms. Austin, and it does appear that she is not a proper respondent and therefore should not be testifying here today. It's my understanding, just very briefly, is that, as we know from the presentation of the facts earlier, is that Hawkins Family Partners is the proper respondent. It looks that Ms. Austin was representing Departure Lounge, which is a building, which is a location inside the building owned by Hawkins Family Partners. They were leasing space, and we sent, TDLR sent a notice to Departure Lounge as a courtesy after being instructed to send it to an additional location by Hawkins Family Partners. So there's a little misunderstanding as to their obligations, and I informed Ms. Austin that we are proceeding against Hawkins Family Partners, and whether or not Departure Lounge has any liability to Hawkins Family Partners is an issue for them to determine, and that's not properly before the board today. Commission.
Some accommodation to reimburse them. They paid some fine amount. Was that?
Commissioner Butler, there was a check sent to the department for $750 seeking an accessibility inspection. We returned that check to Departure Lounge. I was concerned about that also, and so it was fortunate in that instance.
Did I get that wrong somewhere?
I'm sorry?
Did I get that wrong?
No, you're good.
No, we got it. Yeah, they got it all figured out.
Thank you so much, Doug.
Thank you.
So we do have the case before us. The recommendation by General Counsel is to deny the motion for rehearing.
So moved.
We have a motion.
Second.
I'm sorry. Let me correct that. It's to deny the motion for hearing for facts 1 through 4, to grant the motion for hearing for
That was
5.
That was the previous.
That was the previous
yes.
one.
This is in total.
That's right.
Yes.
Okay, I haven't moved off Abraham yet.
Okay.
Let's go back to Hawkins Cole. It is to deny the motion for rehearing.
Yes.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. All right.
Thank you.
That covers the motions for rehearing. Let's go on now to H, which is the Phase 2 rule implementation from the 84th session.
Too far over. Good morning. I'm Wendy Pello, Assistant General Counsel. This is Agenda Item H relating to an overview and discussion of the Phase 2 implementation for Senate Bill 202. We wanted to have a specific agenda item to try and give you a little bit of an overview before we get to agenda items I through N. These are kind of some general background and general overview that will apply to all of those following agenda items. Hopefully it'll keep those tight. You will get some specifics about those particular agenda items when we get to those, but just as a little background, the Texas Legislature enacted Senate Bill 202 in 2015, which transferred 13 occupational licensing programs to TDLR in 2 phases. The first phase, which had 7 programs, was completed on October 3rd, 2016. And the rules that are before you today are the Phase 2, we call them the Phase 2 programs. It's the 6 remaining programs. And they include laser hair removal, massage therapy, code enforcement officers, sanitarians, mold assessors and remediators, and offender education programs. In terms of background on process, unlike a lot of the Phase 1 programs that came over, which had policy boards which were transformed into advisory boards, the programs that are coming in this phase don't have those same advisory boards. So what we did in terms of trying to get public input and be as transparent as we could is that we had informational summits in January, letting folks know this is who TDLR is, what's kind of the process. And then we went back and had additional public summits on drafts of the proposed rules. And we did these summits, public kind of summits, rulemaking summits in March. And we held them in Arlington, Austin, and Houston, and trying to get feedback, an early preview of those draft rules and get some early feedback from industry and the public. When we drafted the rules, similar to what we did in the Phase 1 rules, we started with the current DSHS rules, and we reformatted those into TDLR format in terms of our structure and style. Obviously changed references from DSHS to TDLR, the commission. We also did some reformatting, either used subchapters or made more distinct sections within the rules to make them a little bit more user-friendly to be able to find particular information, particular subjects. We also streamlined the rules. We deleted provisions that were already found in either our Occupations Code Chapter 51 or Chapter 60 rules, which apply to all of the programs. Makes those individual program statutes a lot more streamlined. In fact, according to our count, that we were able to reduce the word count by 42,000 words collectively over those 3 programs. That's a lot of streamlining, yeah. So we think that was a win. Generally speaking, we tried not to make too many substantive changes. Right now, this point in the rulemaking was really to transfer the program from DSHS to TDLR and have that work as seamlessly as possible. So there'll be some specifics about each of those programs, but generally speaking, that was kind of our goal. And each of the attorneys will talk about the specific changes when you get to that particular program and agenda item. As you'll hear for each specific rule presentation, in addition to having that information summit and those public summits around the world, we had public comment on the rules, 30-day public comment, and we also held public hearings during that 30-day public comment period, and we held those public hearings here in Austin for all 6 of those programs. We got a lot of good feedback. Some of those would be substantive changes that at this point in the rulemaking process, we wouldn't be able to make those changes because without having to go back and republish the rules. Other things were substantive changes that we would need more time to study and research those issues as we get more familiar with those programs once they come over and we get those implemented, so that some of those issues would be for future consideration as well. The department also conducted an analysis of the fees for these 6 programs during the rulemaking process, and the department's financial people determined that the fees were above the amounts necessary to cover the cost of administering and enforcing the program. So as a result, the department reduced several fees, which will result in Phase 2 licensees collectively saving over $800,000 per year. The attorneys will discuss the specific fee reductions for each program when they come up for this agenda, but that's a huge savings to those licensees. And then what we're recommending for the 6 proposed rules changes today is to have them be with an effective date of November 1st, 2017, which will correspond with the official transfer of those programs from DSHS to DLR. Yeah, absolutely.
Is that on an annual basis, or is licenses renewed? Do we have kind of an average, or is that biannual?
Yeah, it's what my information is over $800,000 per year.
It stays in the pockets of Texans.
That's exactly right.
Yeah, it's huge. Thank you.
Yeah.
Thank you.
So, yeah, and like each of the attorneys will talk about the specific fee reductions for each of those programs. And again, a November 1st effective date, with a couple of exceptions for the code enforcement and the sanitarians. They will now have advisory boards, and so those advisory board provisions that are within those chapters We're asking for an effective date of September 15th, 2017, so the commission will be able to go ahead and appoint those advisory boards. But the attorney for this program will talk a little more detail. So any other questions or comments or anything just on the overview before we jump into specific programs?
We're pretty excited about the rule, about the fee reduction that Commissioner Collier wants to do the waive. We're excited. I think it's a great thing to know that as Commissioner, Vice Chair Butler said, that $800,000 are being put back in the pockets of citizens of Texas. So I think that we have the ability through our practices and procedures that we do that we're able to reduce fees.
Is that word that gets back to those regulated licensees? I mean,
Absolutely.
Do we have a healthcare letter that goes out from TDLR that?
We are building a healthcare newsletter. We also have the Facebook page that is just for the healthcare programs as well.
Okay.
And trust me, we will not miss a moment of letting folks know what we've done. In fact, part of our story during the legislative session was to talk about the first 5 months and 6 months of the Phase 1 programs, and we talked about the $98,000 that were kept in the pockets of the licensees, the 11,000 phone calls or licenses that we had issued. I mean, we're proud of being in this space, and Kay just provided you a little bit of information. I definitely want to give Wendy the proper praise. This has been a project, and obviously all the general counsels have weighed in, but Wendy has been leading this effort for about 3.5 years now. The success we had for House Bill 4007, that included a lot of the statutory changes that brought about improvement for the Phase 1 and Phase 2 programs, the bulk of that was crafted by Wendy.
Wow.
3.5 years ago, she identified things that were inconsistent with the TLR way, things that would allow for barriers, and of course other staff provided information. But she was right there at the forefront, and it's only fitting that she lead the overview conversation today as she led about 1.5 years ago for Phase 1. But I just want to commend her in public.
Thank you.
As well as the rest of the team and the different program folks that are involved. Stephen Mills' team's been involved, but she sees a lot of her handiwork. And commissioners, that document that we provided to you in front, one gives you the word count reductions. I think that's what TLR is about, smaller, smarter government. We didn't impact the scope of practice for these licensees. We didn't change how they touch their clients, but we removed the fluff and the clutter to make it more consistent, make it crisp, simple, clean, and easy for them to do their jobs and to work with folks. For both phases, it's about 113,000 words that we took out of the rules that didn't need to be there. The clutter that makes folks say, what is this, what am I supposed to do? We've got some work. I know we've got a good contingent here for the massage folks. We've got some work to do on their school rules. Their school rules are still too prescriptive. We are too much in their day-to-day business on how they teach a student and how they say good morning to them and when they say goodbye to them. But we wanted to get the programs here, and we wanted to make sure that we were smart and we had them engaged in the process before we made those type of substantive changes. The other document that we provided to you are the fee reductions, and I know this is something that's near and dear to the hearts of the Texans out there and the licensees, and I know our general counsel folks will identify those fee changes, but it is substantial. I'll just point out a few that I think are a note. When you look at, for the massage therapy schools, their initial school application license is $2,800. I'll just let that linger in the air. That's huge. We've reduced it, or proposed to reduce it, if the commission blesses it, by $1,300. That's a 46% reduction. We're looking at doing a 50% reduction in the renewals for the schools. We're having also that same impact on just the individual licensee. There are reductions of 40%, 50%, 33%, 75% that's included in this package. And at the end of the day, we know that that's what Governor Abbott wants. He wants us to remove those barriers for folks that are getting into business. He wants us to be streamlined, which our rules are doing, and he wants us to do it smarter, but also get out of the way. And I really think the staff did a fantastic job of crafting rules that meet all of those goals and objectives. So this is a good day, and it's a good start for us. And we've got some folks that I think will be speaking on the different programs that are present. I think the chairman has those lists, but I just wanted to commend the GC staff for this last bit of carrying the water, but we had a lot of folks involved in it, so thank you all very much. And Wendy, thank you.
Wendy,
Thank you, Brian.
That's just incredible. And to reduce the word count by 100,000 and reduce the fees, could we say that when you reduce regulation, it saves $8 per word? Is that what we're
And in the hip-hop world, we would say word.
Word to your mother.
I'm gonna go seriously.
I'm gonna try to be cool. Word to your mother.
That did not sound good coming out of your mouth.
Thank you so much for your team.
No,
Maybe you could
Thank
reduce
you,
the words
Commissioner
on the
Butler.
on the commission.
Thank you.
That would probably be a better. Can we set up a team for that, reduction of words?
I may not be as cool as I thought I was.
Well, thank you, and I say thank you on behalf of all the staff, because it's definitely a team effort across all divisions, so say thank you for all of us.
It's wonderful what y'all have done, and I hope they're listening. We're so, me and this is what we live for. The ability to keep money in the Texans' pockets, because they can then reduce what they charge their customers. Our licensees should be over the moon about this. I know I am, and so thank you all so much for what you've done. And I know it's not just you, it's everybody in your
It's
team.
everybody.
And through the agency. If we didn't have a streamlined agency, we wouldn't be able to do this. So thank you so much.
Thank you. Any
Okay,
other?
we'll move on
Chris?
to the next item.
It's me. It's still me.
Move on to agenda item I, which is the proposed rules for the offender education program.
Right. Thank you, Chairman. Again, Wendy Pello, Assistant General Counsel. These are the rules under 16 Administrative Code, Chapter 90. This is a new chapter dealing with the offender education programs. And this program actually is made up of 4 programs. It's the Alcohol Education Program for Minors, the Drug Offender Education Program, the DWI Education Program, and the DWI Intervention Program. And again, this will help, these rules will transfer the program from DSHS to TDLR effective November 1st. As I mentioned, we had public summits on early drafts of the proposed rules. The official proposed rules were published in the Texas Register on April 21st. The public comment period closed May 22nd, 2017, and the department held a public hearing on the offender ed proposed rules on May 12th, 2017. And during that 30-day public comment period, we received written comments from 10 interested parties, and 2 of those same interested parties also provided comments at the public hearing. Based on those public comments, additional department research and review, and some information we received from DSHS staff, the department has made some changes to the proposed rules as they were proposed. One of those is to change the title of the rule chapter just to clarify that if it's offender education programs for alcohol and drug-related offenses. That's because we had a new program being transferred or being sent to TDLR this past legislation about offender education programs for animal cruelty offenses. So we weren't sure how that was going to look in the rules, so we just made the clarification now. A second change we made was just to clarify that in the title of subchapter G, which is now enforcement. We also made changes to Rule 9010, which is the definitions. That was just a clarification cleanup change. Rule 90.25 regarding the instructor in service, the seminar, the continuing education seminar, and that changes to reflect the current DSHS practices about getting credit for taking a class, the continuing education seminar, having it applied to multiple certificates as long as the certificate period is still valid, and as long as they pay the fee for each of those certifications. We've also made a change to Section 9050, which is the program administration. We had some cleanup regarding complaints, and we removed some provisions regarding monitoring based on some additional legal research. We made changes, bless you, to Section 9080 fees, which corresponds with that continuing education seminar. It's the clarification about the fee there. Section 90.91, clarifying the complaints and as it relates to investigations. And then we have withdrawn Rule 90.90 regarding monitoring, again, based on additional research. Again, based for the specifics, getting back to the analysis of the fees for this particular program, we did make 2 additional changes to the fees section. The program provider certification renewal fee is being reduced from $225 to $200 per program. and the fee for moving headquarters to a location outside of the county is being reduced from $300 to $25. So the total savings for licensees for this program is $5,250 per year. So those are the changes. You've got the comments in front of you. I'm happy to answer any questions you have about the comments or our proposed changes.
Any questions for Wendy?
Mr. Chairman, I'll just add something real quickly. This program was probably the most challenging for us to cobble together. The statutory provisions are not as cohesive as you see in other statutory provisions. I would imagine that as we go through the strategic planning process next spring, that we'll have some conversations about some cleanup that we can do in making the statutory provisions even tighter and stronger and more uniform and consistent with other programs that we have. But I think Wendy did a fantastic job, and she lost a lot of hair on this one, trying to figure out how to put together, but she really thought outside the box and was super innovative in helping us get to this, the format that we have. So great job on that.
Thank you. Thank you. Any
There's no
questions?
questions.
Well, then I would.
Motion would be in order to accept.
I can make a recommendation, and if you want to,
Okay.
because it's a little detailed. No, just read it to you.
Don't talk yourself out of the deal.
Sorry. We were just saying, adopt the proposed rules, just to 16 Texas Administrative Code, Chapter 90, with changes to the rules as published, and the specific changes being recommendations to the title of the rule chapter, changes to the title of subchapter G, changes to sections 90.10, 90.25, 90.50, 90.80, and 90.91, and the withdrawal of section 90.90 with an
Motion
effective
figure out what's gonna be.
with an
That's
effective date.
exactly the motion. So moved.
We have a motion?
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Let's go on to item J, which is the discussion possible action on proposed rules for mold assessors and remediators. Laura's at the back.
My name's Laura Pefferly. I'm an Assistant General Counsel. And ditto everything Wendy said about the transfer. My rule that I'm bringing to you is for the mold assessors and remediators program. This is in 16 TAC Chapter 78, part of the Phase 2 transfer from DSHS. As you know, there's no advisory board for this program, so the main sources of input for the rules were the public summits held in March and the public hearing during the comment period that was held in May. And we also have a number of staff who were familiar with some aspects of the mold program at DSHS who have moved here, including myself. I was the mold attorney at DSHS. So we do have some familiarity among staff. The rules were published in the Texas Register in April. After all of the public input, there were 8 comments, public comments, including from the American Industrial Hygiene Association, and changes were made based on the comments and on some changes from the staff. The comments mainly focused on training, qualifications, and technical requirements, most of which we couldn't really implement a lot of change because our goal was to transfer the rules over. We did have to make some significant changes just to adapt them to TDLR processes and procedures. So I would not say that the changes were minor, but they're not particularly substantive. We explained in the comments that a lot of the changes that are being asked for, which basically carry over from the rules at DSHS, were outside of the scope of this rulemaking, but of course they will not be ignored and will be considered in the future. The main changes that were made for adoption are in the notification section. We were still firming up how notifications would be handled. The notifications are significant because they trigger the inspections. So each mold remediation project has to be notified. And the agency is going with an online notification system, which is quite a change from the way notifications and amendments to notifications are done for this program. So the rules were clarified and became more specific about how the notification process will work and how those are submitted. And the other, of course, is the fee analysis. And in this program, the fees for the credentials reduced from between 10 to 25% each, which in dollars is from $10 to $250 per credential, and overall over $210,000 for this program per year reduction. And I can explain more about the different changes that we have made, but for the most part, we feel like they are in the favor of the licensees. They make the procedures clearer, the requirements clearer. This program is geared to protecting the public from mold and from unscrupulous operators, so we think these rules are going to carry forward those goals. And if you have any questions, I'll be glad to answer them before I go into any more detail.
Any questions for Laura?
Mr. Chairman, can I do my normal weigh-in, but in a polite way? Brian Francis, Executive Director. Number one, I want to commend Laura because having her specific knowledge of these programs was invaluable in the process. This program will also be challenging for TDLR. It's a little bit outside of our normal fit. When you see the programs like speech-language pathology, hearing instrument fitters, they follow a standard regulatory scheme. This one's outside just a little bit. The notification process is prescriptive and it is outlined by statute. So we were able to do as much as we can to make it nimble and flexible, but that's something that when we go through the strategic planning process, we'll probably be looking at. As you're aware, there's only 3 states in the U.S. that have a licensing requirement for mold remediation. So that's something we'll be talking about as well. And then finally, this program represents another shining example of some of the best collaboration between the Department of State Health Services and TDLR. We will continue to work with them. They have a high degree of expertise in performing these types of inspections. So Carla has been working with their deputy over there, John Huss, to make sure that we can still rely on their resources. And so we may be contracting with them to assist us in handling that part of the program. So great deal.
How many licensees do we have in this program?
Oh, I'll have to do a quick gander, okay?
Just a rough amount.
Roughly 2,300, maybe. It's
What
not
about, and I
large.
failed to ask for the offender education, how many licensees were in that?
Less than 2,000 for that.
Okay.
It's mostly, it's providers.
Right,
that we
providers
have
for that are licensed, okay. I was just trying to figure out how many licenses.
We'll get those numbers for you as we're going through.
Yeah, if you don't mind, get that at the end of all the rules, if you just tell us
Yes,
how
sir.
many license
Absolutely.
plates, it'd be good to know. Any questions for Laura? If not, do you have a motion for us to?
Yes, and before I make that, I do want to acknowledge the input from DSHS all along and thank them because that was very helpful to us to have their input. My proposal is to adopt the proposed new rules with changes to section 78.10, .22, .56, .62, .64, .70, .74, .80, .85, and .110 with an effective date of November 1st of this year.
We have a motion that's been presented
moved.
to us. We have a
Second.
motion second, all in favor, signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
Laura. Let's move on to item K, discussing possible action on proposed rules for massage therapy. We do have some individuals here to speak, so I will recognize you and ask you to come up here. Thank you.
Mr. Chairman, I just want to point out that Colleen worked on this program, so it's not something that Brad worked on, so if you could throw him some curveballs, that, I think his staff would appreciate that.
I'm sure we can accommodate that request.
Brad Bowman, General Counsel,
Proceed, Colleen.
Mr. Chairman, and members, and I do want to recognize Colleen, who did the heavy lifting, along with compliance and a lot of other staff on these rules. So these are the rules to transfer the massage therapy program from DSHS to TDLR. And as with the other programs, the approach was to not make significant substantive changes, but to reorder the rules, restructure them, streamline them, as well as make some fee reductions, which I'll talk about in a minute. We published these rules in the Texas Register April 21st for a 30-day public comment period. We got a lot of comments in this to this rulemaking. We also held a public hearing in May, and we had good attendance at that public hearing as well. So in total, we had 134 interested parties giving comments, and 12 of those were made during the public hearing that we had. And those comments, you have all of the comments, and they're also summarized for you along with our proposed response to them. I'm not going to go through all of those today, but we just know that we did go through very carefully and read each one of those and respond one way or the other to each of those. The issues that I wanted to highlight for you in this rulemaking, one of the several of the comments pointed out that there was what the commenters described as an additional burden placed on massage therapy schools, which we did not intend, but that was to require audited financial statements on renewal for those schools. And so we agree with the commenters on that that is not an intended burden to place on the schools, and so we removed that requirement, and that's in Rule 117.57, that change to remove that requirement. In addition, there are a number, as has been talked about already, a number of fee reductions for massage therapists, for establishments, and for the massage therapy schools. And those are all outlined in your documents, and the total amount is over $483,000 per year for this program. So with that, I would, if there are any questions, I would offer a motion. No, I'm sorry, we have comments. Yeah. So I'll come back with that.
Any questions for Brad before he leaves? Actually, we can keep up here if you like.
So I know that, yeah, we removed for the audited financial statements, and that's huge there. So what's the requirement to determine financial stability? Because I'm assuming it's looking for that. I can't recall.
I think that's talking about the same issue. That is the requirement to provide financial statements.
The audited, okay.
Yes.
All right.
And Commissioner Collier, just to put in context, one of the things we try to do in the first iteration of the rules is not make substantive changes.
Mm-hmm.
The requirements in their current rules are audited statements on the front end. And then as they renew, it didn't require the audited statements. And we were trying to balance the language saying as required in the previous section, and we in fact or inadvertently raised that standard. And so we just brought it back to where it is today.
Mm-hmm.
We will still be able to review financial information about their situation, but it just didn't require them to go out and get the audit.
Okay, got it. Thanks.
All right, let's move on. We do have some public comments. Colette Lane. Come on up. If you don't mind, state your name for the record.
Sir.
And I believe you have comments concerning the massage rules.
I do. I'm Colette Lane. I'm a licensed massage therapist, continuing education provider, and I'm a part-time massage therapy instructor. So I have a pretty good understanding of this particular industry, and I'm here with you today. Thank you for having this venue. To share some concerns that I have specifically with the massage therapy definition found in the code. Now, I understand that we're not here to make changes in the code, but nonetheless, I would like to present this to you again. And so I'm looking at the definition of massage therapy in Texas Occupations Code, Chapter 455. And for people who don't know where to find this, it's a simple Google term. Texas Occupations Code, Chapter 455, the first list should pull up the definitions. In item number 8, myself and many massage therapists would like to see the definition read for the purpose of health. Because currently how it reads is that massage is for the purpose of massage. So it's not very clear, it's kind of redundant and goes in a circle. Specifically, the goal is to link massage therapy with healthcare, because that is the purpose of massage therapy. That's why people go to school to become massage therapists, hopefully. So just tweaking that so we see that massage is for the purpose of healthcare. Additionally, seeing ambiguous terms like body rub removed from the code. If you scroll down a little bit further in the definitions, item number 11, where it talks about other massage services, and I'm just going to paraphrase that portion, it states the use of oil, lubricant, salt glow, tub, shower, jacuzzi, sauna, steam, or cabinet bath. It doesn't really explain why we would use these items, how we would apply them. And what I'm seeing in the industry is the code as it's written currently is kind of leaving this doorway available for businesses to advertise that they're performing massage therapy when in fact they're doing things of a sexual nature. Also in the code, so that portion I just read where it talks about tub, shower, jacuzzi, sauna, I assume that that might be some reference to hydrotherapy, which the curriculum right now does require that applicants for a massage license have education that includes 20 hours required in hydrotherapy. So hydrotherapy would be more specific, like the application of heat and cold packs for the purpose of improved health, not just throwing ambiguous terms in the code like jacuzzi and shower. Again, where does the massage therapist fit into a jacuzzi? Like, what's the role of the therapist in that? And if it helps, I just did a Google search for Nevada, the state of Nevada's massage therapy definition, just to give some context what I'm referring to. And this will just be very brief. So their code defines massage therapy as a means, the application of a system of pressure to the muscular structure and soft tissue of the human body for therapeutic purposes. And again, I'm just going to paraphrase here. Movement applied manually with or without superficial heat, cold, water, or lubricants for the purpose of maintaining good health and establishing and maintaining good physical condition. Our code doesn't say that, and I'm happy to read what our code says to give context. Our code in other massage services, for example, says include any services offered or performed for compensation at a massage establishment that involve physical contact with a client and may include the use of oil, lubricant, salt glow, a heat lamp, hot cold pack, or tub, shower, jacuzzi, sauna, steam, or cabinet bath. This is pretty vague. And as far as what rule this might fall under, it looks like it falls under item 117.2, create definitions to be used in the massage therapy program. So those are my comments. That's all I have. Thank you very much.
Thank you.
I
Appreciate
do
it.
like the sound of fee reductions for therapists. So, thank you.
Figured like that.
Yes, thank you.
Thank you.
Thanks.
Thanks
Next
for
up
being
is Kathy German.
Yes, hello. Thank you for having me. I'm Kathy German. I'm a licensed massage therapist and massage therapy program director for Avenue 5 Institute. And I'm really grateful for the opportunities we've had to give feedback and understand also that we're not here to necessarily change the rules going into place. I did have a question just to make sure. One of the changes I had heard was going to happen in November was that they were going to drop the requirement for the jurisprudence exam, and I just wanted to check, one, if that's still applicable.
There's your curveball.
Yes, Go ahead, Brad. And I'm trying to remember, this is Brad Bowman, General Counsel, I'm trying to remember that discussion, but the requirement is still in the rules, in the document that we have currently. And I think that's been consistently how we've approached these DSHS programs coming over, is that jurisprudence exam is a common component of those programs, and we've kept that in place at least for now.
That's correct.
And so that's been the approach thus far.
I hope that answered your question.
Yeah, thank you. And also just as we move forward, a couple of things that I know are important to our schools, like Brian mentioned earlier, is just the reduction in the requirements that specify how we are to deliver our curriculum. And so right now, instead of listing out, like most states, that there's certain requirements for a particular course, it actually goes through an entire outline of every class and what we should be teaching to the T, which means that every school in Texas is teaching exactly the same thing with not a lot of room to really call in the professional expertise of the instructors that are actually giving that particular lesson. So I don't know if that is something we're bringing on board, that entire detailed outline, or if that's something that's an option to be dropped.
It is something, Mr. Chairman, Brian Francis, Executive Director, it's something that's coming on board. On day one, it'll be there.
Okay.
But once the advisory board's in place to really provide us with that specific expertise from the different schools, like we have with the cosmetology and barber programs, we want to make some intelligent changes in that area and also be transparent with it. We didn't want the first handshake with the program to say, oh, by the way, we changed your world.
Okay.
Over time, and you see that with our Phase 2 programs, we are now going into the curriculum and the scope of practice issues for driver education, speech-language pathology, hearing instrument fitters, orthotists and prosthetists and those groups, and you'll see that same pattern of timing go along as well once we get you here.
Great, thank you.
Thank you.
Another one is 117.51. It talks about massage school locations. And right now it says that pretty much everything you do needs to be on site on an approved location. And as interpreted from conversations I've had with TDSH, that would mean that we aren't legally allowed to go do community service with like chair massage events with a licensed instructor. That's pretty common practice in many states to actually be able to get your students involved in outreach programs, sports events, Boston City Limits, TDLR meetings, right? We just bring our chair massages and set up and do that, and the students get great experience. They also give a chance to give back to the community. Right now, it seems like that's interpreted as something that is not permitted, and so I'd really like to see that change. It's not stated like that in the code, so it's a question of interpretation of where we'll get guidance for that as soon as things come on board on November 1st, because it doesn't say, it just says you have to be at a licensed establishment, but it doesn't necessarily say you can't. I mean, I guess that's what it's saying, but it just, I would like to see that something that we can actually work with to be able to give back to the community.
We'll definitely take a look at that.
Yeah. Okay, great. The other item would be 117.59, which is letter K, which happens to do with not accepting tips or compensation while those students are in school. And I think we have other programs out there that actually allow in their internship section to be able to take client tips while offering services during internships. So that would just be a question of at what point massage might be able to do that as well. All right, thank you very much.
Thank you, I appreciate it.
Everything, and thank you for an advisory council for massage therapy. Yeah.
I'm glad you mentioned that. We are currently receiving applications for the Massage Therapy Advisory Board, and we hope to be able to have that appointment at our next meeting. So I'll be meeting with staff to do that. So we do have a number of applications.
I think we're at 86 as of Monday, Mr. Chairman. But just to say that they're falling a little behind driver education, which was at 160. I'm not throwing the gauntlet out for competition, but if it was, they're a little bit behind.
So we also have David Lauderty Is that right? Come on up. You don't mind state your name for the record?
Sure. David Lauderstein with the Lauderstein Conway Massage School here in Austin. And I just want to say that our experience with the TDLR so far has been extremely user-friendly, surprisingly so, and that the staff has been very responsive and helpful. Brian and Rhonda Reinhardt and Colleen Tran, all quite fantastic. And the process, including places where we had certain questions, has been extremely transparent. I just want to congratulate you all and thank you very much, and I look forward to future positive things happening, and delighted to hear about the fees and the advisory board and so on. So thank you very much.
Appreciate it. Thank you, sir.
So much.
There being no further questions or comments, anyone else here to speak? Any more questions for Brad? Brad, I'm sure you probably have a motion for us.
Yes, sir. The motion would be to adopt these proposed rules with changes to sections 117.55, 117.57, 117.100, with an effective date of November 1st, 2017.
We have a recommendation for a motion.
So moved.
So we have a motion and a second, and we'll take that as a second.
Yes, sir.
All in favor signify by saying aye.
Aye. Aye.
Those opposed, motion carries. We look forward to working with y'all. I just want you to know that. Thank you. Let's go to item L, which is the discussion possible action on proposed rules for laser hair removal.
Again, Brad Bowman, General Counsel. This was also a Colleen Tran's program, so I'm filling in again here. These are the rules to transfer the laser hair removal program from DSHS to TDLR as a result of Senate Bill 202. We published these rules in the Texas Register on April 21st for a 30-day public comment period. We also held a public hearing on May 12th. We received 2 comments, and the comments were from the public hearing that we had. We've discussed those comments in the summary document. We're not recommending any changes to the rules based on the comments, other than one of the comments touches on the fees, and as with the other programs, we're recommending fee reductions in some of the fees. And the reductions here are to reduce the initial and renewal fees for the registration. And if I can get the dollar amount for you, that is
$510.
$510.
$510 reduction.
yes, and the total would be $73,000 in reductions annually. And so, with that, I will, if you have any questions, I have a motion for you. I don't know if there's anyone signed up to
Anybody signed up for
testify.
comments? Anyone here for comments? Okay.
Mr. Chairman, I'd like to weigh in, just kind of do some foreshadowing. Laser hair is probably the second most challenging program that we have because it's very different. You have devices and you have individuals that use the devices. You also have a little bit of overhang with a device that's used for medical purpose and a device that's used for a cosmetic purpose. We have those for cosmetic purposes, but they're typically the same machine depending on where you set it, where you set the dial. And so we're still having some very interesting conversations with the Department of State Health Services because the medical devices remained over there and maybe even the devices did as well. So we're still working through that. It's not a clean handoff, but we'll be able to implement it well and get it done on November, but there'll still be some ongoing conversations on this one.
Your recommendation for motion?
The motion would be to adopt these rules with changes to 118.80, which are the fee reductions, with an effective date of November 1st, 2017.
So moved.
Second.
We have motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Thank you.
I would make note also, thanks Brad, that Commissioners, we did receive the population for our programs, and this particular one is about 2,300, a little over 2,300. So, let's go on to item M, discussion possible action and proposed rules for code enforcement officers.
Thank you, Chairman. Commissioners, again, Doug Jennings, Assistant General Counsel for the Department. I'm going to be up here for 4 agenda items, so
For the rest of 'em?
let's have a nice, productive discussion. The first item before us is bringing over the Code Enforcement Officers Program from DSHS to TDLR. In line with some of the other rules that you've seen, we made a roughly 40% reduction in word count on this program, on this program's rules. I think they're a lot clearer, a lot easier to understand. In your materials, you'll see the details about publication. For this program, we received three sets of comments, very helpful. I believe some of the commenters are here in attendance today, which is going to really help drive development of this program. We weren't able to make many changes to the rules as proposed, but we did make one significant change, and that is to the definition of code enforcement. The definition that we proposed earlier was based on an earlier DSHS rule, and believe it was a unintended misstatement of the law. And so we changed the definition of code enforcement to reflect the statutory definition, just copied it verbatim, so there's no potential for conflict there. And also, there was a recommendation for reducing fees for renewal for code enforcement officers from $100 to $75, which is going to result in a savings of $22,250 per year. After addressing any questions, my motion is going to be a little different than the ones you've heard before. We'd like to go ahead and put the advisory committee in place, so I'm going to ask you to adopt certain rules with an effective date of September 15th and the remainder of the rules with an effective date of November 1st. And I can go into that.
Okay. I don't know, I don't believe we're gonna have a commission meeting prior to September 15th, which means that we won't be able to appoint an advisor. Are we doing that right now?
We're looking at doing that, Mr. Chairman, at the next meeting, which will probably be maybe October 20th, if the commission agrees to it. So we'll still need this early effective date, so that section of the rules gives you the ability to do that.
Oh, to do it, got it.
Yes, sir.
My apologies. So, okay. Any questions for Doug? Or, of course, I'm sure our executive or illustrious executive director will want to.
I just want to give context to
comment.
the code enforcement program. Number one, we know that the massage therapy individuals were contacting us 4.5 years ago when there was a hint that the programs may be coming to TDLR. Code enforcement was right on the heels of that. They have been one of the most engaged programs. They have been a delight to work with. George and David Gonzalez have created already some strong connections. We were doing presentations at their conferences 2.5 years ago, before the program was even said to be coming to us, and they have been engaged ever since. If you've attended any of the focus group sessions that we had, those are some of the more highly attended groups, and they're not our largest licensed population, but they're very engaged, and it's been great. And like Doug said, when you get the input from the industry, it makes the transitions go so much smoother. No one's caught off guard, and everyone feels like they have input and they have an opportunity to contribute. So I just want to tell you that this is going to be a really good group for us to work with, and it's going to have some nexus with air conditioning and with IHB and with the electrician program and those sort of things.
Recommendation for motion?
I recommend that you adopt Rule 62.1, 62.10 with changes, and Rule 62.65 with an effective date of September 15th of this year, and then adopt the remaining new rule sections with changes to Rule 62.80 with an effective date of November 1st of this year.
We have a recommendation for motion.
So moved.
We have a motion
Second.
and a second.
Aye.
All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Doug.
Thank you.
Next item is item N, discussion possible action of proposed rules for the sanitarian program.
Thank you, Chairman, Commissioners. Again, Doug Jennings, Assistant General Counsel. Similarly, moving the sanitarians program from DSHS to TDLR. You can see the details about publication. We received comments from 3 interested parties. However, they did not drive any changes to the proposed rules. They were mostly requesting statutory changes, which, as you know, is not our domain. We have made several structural, well, actually just editorial and stylistic changes to the rules as originally proposed, which we think the rules are much clearer than they were when we first presented them to you, and it will be a lot more easier to understand for the licensees. And we've recommended reducing a number of fees, four different sets of fees. For initial registration and for renewal, the reductions range from $5 to $30 each. You can see that in your executive summary. And that's going to result in savings amounting $16,320 per year. And again, kind of a two-tiered recommendation for our motion because we'd like to get the advisory board in place for this program also.
Any questions for Doug? We'll go and proceed forward since our executive director is not at the mic. You have a recommendation for a motion?
I do. I would recommend that you adopt Rule 119.1, 119.2, 119.10 through 119.15, all with changes, with an effective date of September 15th of this year, and then adopt the remaining new sections with changes to 119.21, 23, 24, 26, 27, 70, and 80, with an effective date of November 1st of this year.
We have a motion?
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir.
Thank you.
Now we'll go on to item O, discussion of possible action to propose amendments to existing rules for the National Electric Code.
Yes, and commissioners and chairman, we are moving out of the Phase 2 into just different sets of program rules
Got
at
it.
this point. So this is not part of the Phase 2 program. So we are, I'm sorry, I had them reversed. So this is the electrical code. So this is a proposed amendment to Rule 73.100 of the electrician's rules. As you may know, the Electrical Licensing or Electrical Safety and Licensing Act requires that the department adopt an updated National Electrical Code every 3 years. We are currently operating under the 24 edition of the National Electrical Code, and we'd like to adopt the 2017 edition. We received one comment after proposing this rule, which was cleared by the advisory board. We just recommend adopting the proposed rule without changes. And we do need to make one change. So you'll see in the text of the rule, I believe it says effective September 1st. We'd like to make that effective September 15th.
Okay.
And if we have any questions, we have Jerry Daniel from our compliance division here to answer any technical questions you might have about changes to the NEC.
Any questions for either Doug or Jerry Dan? A motion be in order with the recommended adoption of September 15th.
Yes,
So
sir.
moved.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carried. Item P, discussion possible action on proposed rule amendments to the Uniform Mechanical Code
Thank you.
and Residential Code, I'm sorry.
Yes, thank you, Chairman and Commissioners. Again, Doug Jennings, Assistant General Counsel. Now, this one is a little bit interesting. Let me just tell you that the proposed rule was recommended by the ACR Advisory Board. However, at our last meeting, we were unable to reach a quorum. And so, even though this rule was drafted at the behest of the Advisory Board, we didn't get their official seal of approval on this. However, there were 4 members present at the meeting, and they all expressed their approval, even though that's not an official action. But we do not have any reason to believe that there is any, the industry has any qualms about upgrading to these codes. And just to be clear, we would be amending Rule 75.110, so we would be updating several codes. So the International Mechanical Code, the Uniform Mechanical Code, the International Energy Conservation Code, the International Fuel Gas Code, and the International Residential Code to their most recent versions. And that would be effective January 1st of 2018. And so that's just to give a little lead time to our licensees.
I just asked Commissioner Shaw, who of course is involved with the city of Carrollton and works in kind of that area, and he said that they do follow this code now also themselves, so I guess it's a very current code.
Right, it's interesting, in the ACR program, municipalities, they follow codes that they've adopted by local ordinance, but in an area outside a municipality, we have certain other codes that must apply, and that's really what this is. This is kind of revising the codes that apply to those non-municipal areas.
All right, so do we have a motion? He's already given us.
Are you gonna make a motion?
I would recommend that we adopt this rule proposal without changes with an effective date of September 15th, 2017. That means it will go on the books as soon as possible. The text of the rule will say effective January 1st, 2018.
So moved.
Motion. Second. Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir.
Thank you.
Thanks.
Move on now to item Q, discussion possible approval of the penalty matrix for the speech language pathologist and audiologist program.
Good morning, Commissioners. I'm Karen Cox with the Enforcement Section, and I am here to recommend for adoption the speech language pathologist and audiologist penalty matrix. This particular penalty matrix was adopted by the SPA Advisory Board in their June 30th meeting. It follows the standard format that all of our other penalty matrices do, with the less serious violations in Class A, and then increasing through Class B, Class C, and the most serious in Class D. I would like to acknowledge at this time the essential contributions of the enforcement work group from the advisory board. That was Dr. Tammy Camp, Dr. Kristen Culp, and Chair of the Advisory Board, Sherry Sansibrian. Those three ladies met with enforcement staff twice to produce a draft. I would also like to acknowledge the above and beyond the call of duty contributions of Chris Russi, the enforcement, without whose production this would without whose work this would not have happened, and recommend that the penalty matrix be adopted by the commission. May I answer any questions?
Are there any questions? Entertain a motion?
So moved.
Second.
Motion and seconded. All those in favor, please signify by saying aye.
Aye.
Thank you very,
The motion carries.
thank you very much.
Moving on to item R.
Morning, Commissioners. Again, name's John Melick, again presenting the Hearing Instrument Fitters and Dispensers Penalty Matrix. This penalty matrix, like much of the other health-related programs, penalty matrix has gone to a single range of violations, with, again, Class A's being the least serious and Class D's being the most serious. It's a product of the work group that was made up of the department staff, advisory board members Ms. Jackie Cooper, Richard Davila, and Jesse Rangel, whose help was instrumental in creating this document. It was presented before the full advisory board on July 26th of 2017, where they approved the recommendation to send it before the commission for your adoption. I'm going to be asking for you to adopt this penalty matrix, but with a little bit of a caveat that it not be effective until September 1, because due to some changes in House Bill 4007 that took out some specific languages in the hearing fitter statute, we went ahead and made those changes in the penalty matrix instead of having to redo it twice. So with that, I would ask you that you would adopt it with that effective date of September 1. If you have any questions, I'd be happy to answer them.
Are there any questions for Mr. Medlock?
So moved.
Okay, we have a motion. Do we have a second?
Second.
All those in favor, please signify by saying aye.
Aye.
The ayes have it, and the motion carries. Continuing on to item S, before you, we have a list of appointments to the Air Conditioning Board, Air Conditioning Refrigeration Contractors Advisory Board, the Elevator Advisory Board, the Licensed Breeder Advisory Board, the Midwives Advisory Board, the Texas Tax Professional Advisory Board. Have y'all had a chance to review those?
Yes, we did, Mr. Chair, and I'll make a motion to approve the appointments as presented.
Second.
So we have a motion, we have a second. All those in favor, please signify by saying aye.
Aye.
The ayes have it, the motion carries. Continuing on, item T.
Vice Chairman Butler?
Yes, sir.
One of the practices that we put in place just recently is if you could read those names so that if there are people listening, they'll be able to know if they have to drop confetti or
Absolutely.
or not. Thank you so much.
Thank you, Brian.
I appreciate
Okay,
that.
so for the air conditioning, I'm sorry?
No, sorry.
The Air Conditioning and Refrigeration Contractors Advisory Board, we appoint Gary Halsey from Hazlet, Texas, Mr. Robert B. Stanley from Canyon, Texas, Mr. William R. Weatherly from Austin, Texas, and we appoint the presiding officer as Dolores Compian from Richmond, Texas. Thank you so much for taking time out of your schedule to serve on the advisory board. We look forward to getting to know y'all and the work that you're going to provide for us, so thank you so much. The Elevator Advisory Board, we reappoint Brian Morris from El Paso, Texas, Mr. Scott Anderson from Houston, Texas, Grayson Gill Jr. from Dallas, Texas, and Greg Temez from San Antonio, Texas. Likewise, thank you so much for serving on that board. The Licensed Breeder Advisory Committee, Cynthia Rothermel from Alvin, Texas. Andrea Grieg from Lakeway, Texas. We also reappoint Richard Cordes, Doctor of Veterinary Medicine from Menard, Texas. Babette Ellis from Austin, Texas. Josephine Levine from Burleson, Texas.
That's Joseph.
Joseph Levine, thank you so much for catching me. The Midwives Advisory Board, we appoint Destiny Hooper from Pearland, Texas. The Texas Tax Advisory Professional Advisory Committee, Brian Noonan from Austin, Texas, and Brian Ebersole from Haslett, Texas. Thank you one and all for your willingness to serve the good folks of this state, and we appreciate your efforts and time.
If I may,
We get
Chair.
that motion?
Yes.
Yes, sir.
Perfect.
Right.
Thank you very much.
We're very productive.
If I may, before proceeding, I know that one of the things that came up with the Midwives Advisory Board for one of the meetings that I attended was the concerns about, the distance, that they travel and having folks maybe in close proximity. I don't know how successful he might have been. I mean, this person's from Pearland, so I guess it's a little bit closer.
It's closer. One of the
Yeah.
things that the chairman does when he's going through the final evaluation of those applicants is he contacts them. And they're aware of the lack of travel funding and that sort of thing. So it's something they're cognizant of. We also try to be mindful of it when we're doing the work groups, that we can do those via phone. And so that's really where the heavy lifting for the boards takes place during the work groups. And then finally, we try to get the meeting scheduled far enough out in advance so they can make arrangements, even though sometimes babies trump our meetings.
Sure, sure. I just know this is one of the things that came up that was discussed from the
Yes, sir.
board.
Yes, ma'am.
And I know that this board, along with some other communication from other boards, wish that there was some travel compensation or reimbursement allowed for them. Unfortunately, we don't have that. So just try to make it aware to them that serving on this advisory board would be great for the industry and great for us. But unfortunately, we don't have the ability to reimburse them for some of their travel unless we make some changes statutorily from a budget standpoint. If they gave us some money, or the legislature gave us money, which they don't. So-
Sure, but the video
Right,
calls.
yeah, exactly.
Sure.
The other thing I would want to mention also, we do have public member board appointments that are currently vacant. We have a vacant position on the Auctioneer Advisory Board, the Board of Board and Rules, Dietitians Advisory Board, Elevator Advisory Board, and Hearing Instrument Fitters and Dispensers Advisory Board. We actually have 2 positions open there. These are all for public member. So if you know, commissioners, if you know anyone that may be interested in serving on those, or actually just participating and being a part of it, then of course, we would ask that you push them in the direction to apply, because we're trying to get these positions filled.
Okay.
Let's go on to staff reports. I think that at this point in time, Carla, I believe, are you up
Mr.
for
Chairman,
that?
we were very cognizant of the time constraints and the length of this meeting, so we don't have any exact staff reports
That's fine.
available. Brian, myself, and Nick are available for any questions you all may have.
So, if you have anything, of course, you do have the staff reports in your packet. I would encourage you to read those. They do provide a lot of information for us. Let's move on to item U, the advisory board report. Do we have anything on that?
Yeah, and I guess before, what are we doing? Where is that?
Item U, advisory board reports. Nothing on that? You do
Yeah.
have that in your packet information also?
Yeah, I did see that earlier. I do, and Carla, you can share it with me later. I do want to get a HUB plan update over the written one that I had before, and have a couple of suggestions as we talked. Thanks.
All right, moving on to item V, public comments. It's an opportunity for anyone that's in the public that would wish to make a statement to the commissioners. You have 3 minutes at this point in time to make any comments. I don't see anyone here stepping forward, so we'll move on. Item W, discussion of date and time. The staff has asked us to consider our next meeting to be October the 20th.
Yes, sir.
This would be able to allow us to have some time to collect some, of course, more contested cases, most we're hearing, but it'd probably be a sufficient amount of time distance in there. At that point in time, you would be seeing some appointments to these various boards, advisory boards that we're needing. we do. As you could tell by the rules, Phase 2 rules that we have passed today, I believe all but one have advisory boards to them. So there'll be a lot of appointments coming to you then, not to mention the one that we'd have to replace anyway. So we're looking at October the 20th.
What day is that?
That would be on,
It's a
I believe
Friday.
Friday. Of course, I think all of these meetings would be on a Friday, which is kind of where we landed at the last time we want these to be at. October the 20th would be a Friday. The next meeting would be the probably December the 8th. That is, they're saying the week of December 4th, so we look at December 8th. March 26th of 2018. Well, I'm sorry, the week of. So that would actually be March 30th. December 8th, March 30 of 2018, and then May 25th of 2018. So if there are no objections, we'll go ahead and set our date for October the 20th, 2017, and December the 8th of 2017. And then we'll tentatively schedule our next two meetings for March the 30th of 2018 and May 25th of 2018.
Mr. Chairman, I'll just add that those are the dates or time periods that we need to accomplish the implementation of the different legislation that came out this session. Obviously, the commission will have other drivers in between us, but those are going to allow us to meet those statutory requirements that are included in the transition language. So that's part of our timeline, and we know that you guys will have your business as well that you'll need to maybe accommodate in between those.
Everyone good with those?
I'll be out the 8th. That's-
December 8th? I'll be out December 8th also. So,
Yeah, and I think I'm tentatively gone on the 20th, but I'll let you know.
okay. Yeah, if you don't mind, let us know or let Kay know on the 8th or the 20th or any of these dates that you're going to be out, just to ensure we do have quorum. I can tell you, without any appointments, we may be pushing to have a quorum on the 8th of December, because that puts us at 4 if Winter Yurko is available, which is fine. I'm sure you guys will be able to conduct business without myself here. I know you can do it without Rick, but
We're gonna get something done without you two guys.
Mr. Chairman, we don't have any meetings for January or February. Does that affect our caseload, or can we get by not having a meeting in January and
I don't
February?
know.
It's always going to depend on the cases that are in the pipeline. And Brad's team is always analyzing the number of days that are related to the district court appeals, but also the time of the cases. And that's one of the things that we talked to the chairman about. If there's like a cancellation of the meeting, we figure out what the impact will be on the different
Okay.
cases. So that's something we will be mindful of as we get to those dates.
Thank you, sir.
Yeah, I noticed that too. I was like, December and March, that's a pretty long stretch there.
Long haul.
So, I don't know. We'll see, but we'll play it by ear and
Absolutely.
kind of, we'll just have these set up tentatively anyway, so we'll work through that. I believe we took care of all the contested cases, motions for hearing, all the rules are done and penalty matrix. There being no further business to be brought before this commission, we are adjourned.